Welcome to Employment Law This Week. I'm George Whipple. The Supreme Court is closing out its term, and the justices have already handed down several decisions that require employers to adjust their policies and procedures. This week, we're taking a look at a few of those key opinions and looking ahead at what's still to come before the term ends this month. In April, a discrimination claim led to a unanimous Supreme Court decision expanding Title VII's reach. In Muldrow v. City of St. Louis, the court held that employees do not have to prove significant harm to support a workplace bias claim. The court also took up the issue of arbitration in several different decisions this term, all unanimous. In Coinbase v. Suski, SCOTUS ruled that where the parties have agreed to two conflicting contracts, with one sending arbitrability disputes to arbitration, and the other either explicitly or implicitly sending arbitrability disputes to the courts, a court must decide which contract governs. Smith v. Spizzirri continues the trend of court decisions giving primacy to the Federal Arbitration Act. In this case, the court found that Section 3 of the FAA requires a court to stay its proceedings pending arbitration, and the court lacks discretion to dismiss the suit. And the court's decision in Bissonette v. LePage Bakeries interprets an FAA exemption expansively, making it easier for plaintiffs to avoid arbitration. The court held in that case that a transportation worker need not work in the transportation industry to be exempt from coverage under Section 1 of the FAA. Additional employment-related cases are still to be decided before the term ends, including two addressing the authority of federal agencies. One case considers the standards lower courts use to evaluate NLRB injunction requests. The other case could result in a major shift in the federal regulatory system. The Supreme Court is considering two cases challenging its 1984 Chevron decision. That decision broadly empowered courts to defer to agencies' reasonable interpretations of ambiguous statutes. A full rollback of Chevron deference could significantly rein in the authority of federal agencies, impacting how Congress writes statutes, how they're enforced, and how the courts review them. That's it for this week. Thank you very much for watching, and we'll see you next time.